Please be seated. Yes, Mr. Mitchell.
Thank you, Your Honours, and good morning, everyone. I'm going to respond briefly to some of the arguments raised by the defence for Drago Nikolic in their final brief. First, I'd like to address some of their arguments about Drago Nikolic's contributions to the two joint criminal enterprises he's been charged with. Second, I'll address two discrete legal issues in relation to state policy to commit genocide and conspiracy to commit genocide. Finally, I'll address the defence's submissions on mitigation. Before I start, I'd just like to say a few words about the defence's final brief. This document contains a number of errors of law, of fact, and of analysis. It won't be possible to identify all of these errors today, but I would briefly like to highlight a couple up front, and I'll address others in more detail as I go along. Of paragraph 667 of their brief, the defence state that another important issue is the fact that Gullich, referring to Mihailo Gullich, was responsible for mobilisation matters, that there were many mobilisation issues which happened during the period of 13 to 15 July 1995, and that Gullich denied being involved in any of them. This isn't a fair representation of Gullich's testimony. At transcript page 10514, Gullich confirmed that he actually met the new recruits on the morning of 15 July. Another example appears at paragraph 675 of the defence brief, where they claim that 3 military experts, including Richard Butler, agreed with the suggestion that Dragan Abrenović would have personally selected the officer who would replace Drago Nikolic at the IKM on the night of 13 July. At transcript page 20448 to 20449, Mr. Butler said the exact opposite of what the defence have quoted. Mr. Butler said, "I would have expected that Major Abrenović would have verified that the position was filled. I don't believe that within the context of the operations staff that it would have been necessary for Major Abrenović to handpick the next duty officer." Another misstatement appears at paragraph 574, where the defence state that Damjan Lazarević testified that Drago Nikolic was not involved in the reburials. Again, this isn't a fair reflection of Lazarević's testimony. At transcript pages 14507 to 14508, Lazarević simply said that he didn't see Drago Nikolic during this period. I don't want to belabour this point with any more examples. We have no doubt that Your Honour will scrutinise the submissions of all parties in this case very carefully. I'd like to turn now to the defence's arguments about the joint criminal enterprise to murder the men from Srebrenica. And the first argument I'd like to address is the argument that Drago Nikolic was not relieved from the IKM on the night of 13 July. It's uncontested that Drago Nikolic was the duty officer at the IKM during the day and the early evening of 13 July. The evidence has shown that at around 7 or 8 p.m, Drago Nikolic received a call from Vujedin Popović, who told Nikolic to prepare for a large number of prisoners who were being brought to the Zvornik area to be shot. Later that night, Momin Nikolic personally told Drago Nikolic that those prisoners were going to be executed. Drago Nikolic called his commander and was authorised to leave the IKM and take some Zvornik Brigade military police and the military police commander, Lieutenant Jasikovac, to organise the detention and the execution of those men. Mihailo Galic testified that he replaced Drago Nikolic as the IKM duty officer that night, and the IKM logbook, which is Exhibit P347, confirms beyond any doubt that Drago Nikolic was replaced by Mihailo Galic. We know that the first prisoners arrived at the Arahavat school that night, including PW 169, and we know that Zvornik Brigade military police were deployed to the school, including Stanoje Bacharkovic, Dragoje Ivanovic, and PW 143. At transcript page 6532 to 6533 and 6611 to 6612, PW 143 testified that he actually saw Drago Nikolic at the Arahavat school that night. Drago Nikolic was the assistant commander for security. The arrival of these prisoners and the deployment of the MPs to guard them required his personal presence at the school that night. He had to be relieved, and he was relieved. Now, the defence have argued that Drago Nikolic did not leave the IKM that night. They argue that the witnesses, Mihailo Galic, PW 168, PW 143, and Momin Nikolic were not credible. I don't intend to respond to this in any detail. These witnesses were reliable, they were consistent, and they were strongly corroborated. And I'd just like to direct your honours to paragraphs 2615 to 2646 for our detailed submissions about these witnesses. The second point that I want to address is raised at paragraphs 680 to 698 of the defence's final brief, where they claim that there's evidence that the IKM logbook has been tampered with. Your Honours, I have the original book here if you'd like to take another look at it. But very simply, this book is reliable, it's contemporaneous, there's absolutely no evidence that it's been tampered with, and there's no evidence whatsoever that Mihailo Galic fabricated the key entry. The defence's arguments about this book are also contradictory. In paragraphs 688 and 690, they suggest that pages may have been removed from the book. On the other hand, paragraph 694, they argue that it's suspicious that there are no pages missing from the book. You can't have it both ways. There is no credible basis for their arguments about the integrity of this book. Thirdly, Drago Nikolic relies on the evidence of Dragan Stojkic to support his claim that he remained at the IKM that night. But Stojkic's own testimony showed that he can't have been at the IKM on the night of 13 July as he claimed. Stojkic was a member of Tactical Group 1, which went to Srebrenica and Žepa. Transcript pages 21971 to 21973, Stojkic testified that he stayed at Crni Rijeka on the night of 11 July while he was en route to Žepa. According to him, he participated in fighting the next day near Žepa, which would have been 12 July. And the next day, he returned to Žepa and went to the IKM. That was 13 July, according to him. It's clear that Stojkic's testimony and his timeline are 2 days out. Tactical Group 1 stayed at Rijeka on the night of 13 July and participated in 1 day of fighting near Žepa on 14 July. An example of that evidence came from Dragutinović at transcript page 12591 to 12592. If Dragan Stojkić stayed at Crni Rijeka with Tactical Group 1, it had to have been on 13 July, and he couldn't have been at the IKM, as he claimed. Of paragraph 654 of its brief, the defence also suggests that Stojkic's testimony is corroborated by the fact that a tank company from Tactical Group 1 returned on the 13th of July. This is completely irrelevant. Stojkić was not a member of a tank company. Moreover, if Stojkić had returned on the 13th of July, he couldn't have participated in that 1 day of fighting near Žepa on the 14th. Your Honours, Stojkić was clearly mistaken about the dates when he was at the IKM, and his testimony cannot support the defence's claim that Drago Nikolić remained at the IKM on 13 July. The totality of the evidence on this point proves beyond any reasonable doubt that Drago Nikolić was relieved of duty at the IKM on the night of 13 July. The defence has also argued that Drago Nikolić thought that the men who were brought to Zvornik were going to be exchanged. This argument is completely implausible. First, the evidence has shown that Popović and Momin Nikolić explicitly told Drago Nikolić on the night of 13 July that these men were going to be executed. Secondly, this looked nothing like an exchange. As outlined at paragraphs 2647 to 2666 of our final brief, there is no legitimate explanation for placing these prisoners in schools in the Zvornik area rather than the back of each camp. These prisoners were kept in appalling conditions. They had no food, no medical attention. They had insufficient water. Their personal belongings and their identification were stripped from them. And most importantly, there were no lists made of the prisoners, and there was no one to exchange them for. Drago Nikolić was the assistant commander for security, and the evidence has shown that he had been involved in exchanges since at least 1993. The reference for that is Exhibit 3D 7D 00454. Had Drago Nikolić genuinely thought that those prisoners at the Arahavat school were going to be exchanged, the first thing he would have asked when he went to the school was, where are the list of the prisoners and who are we exchanging them for? This was no exchange, and Drago Nikolić knew full well that this was no exchange. The defence have conceded that Drago Nikolić was at the Arahavat school twice on 14 July, and they also concede that he will probably incur some liability on that basis. However, at paragraph 71 of their brief, the defence argue that Nikolić did not have any role in directing, supervising, or assisting the preparation or the organisation of the execution of the prisoners there. Now, Mr. Nikolić's role in coordinating the events at Arahavat is discussed at great length in our brief, but I would like to respond to this briefly and highlight the key parts of the evidence of his coordinating the events at the school and at the execution site. Dragoje Ivanović testified that at around 8 a.m. on the 14th of July, Drago Nikolić arrived at the school. I'd just like to read you a short section of Ivanović's testimony on this point from transcript page 14544. In the morning, around 8 o'clock, the Brigade Chief Nikolic came, and shortly afterwards, some 20 to 30 soldiers arrived as well. He told Yasikovats that we were free to go, but that we should be ready and close by with the minibus. He told that the soldiers that arrived with him were there to take over the civilians. Ivanović's testimony establishes clearly that Drago Nikolic was coordinating the changeover of security from the MPs who had arrived there the previous night to the soldiers who arrived there that morning. This necessarily means that he was coordinating and overseeing the detention of those prisoners. Just to be clear, it's Lieutenant Yasikovats who gave the order to those MPs to stay around, but it's equally clear that Lieutenant Yasikovats was passing on Drago Nikolic's instructions to the MPs. This is a perfect example of how the relationship between Mr. Nikolic, Lieutenant Yasikovats, and the military police worked both by regulation and in practice. Later that morning, Drago Nikolic went to the Hotel Vidakovats with Milorad Bačarković, and he met buses full of prisoners who had come from Bratunac. At transcript page 11054 to 11055, Milorad Bačarković testified that Drago Nikolic told him to get onto a bus and go to Arahovac. He's put the additional security in place that morning, and now he's coordinating the arrival of the additional prisoners. At around 11 o'clock, Nikolic returned to the Arahovac school, and over the next few hours he was seen by numerous witnesses, including Milorad Bačarković, at transcript 11022, PW 142, at transcript 6451 to 6452, PW 143, transcript 6536 to 6538, Stanoje Bačarković, transcript 10748, Dragoje Ivanović, transcript 14544 to 14548, Tanachko Tanic, transcript 10337, and PW 101 at transcript 7573 to 7534. PW 142 saw Drago Nikolic speaking with senior, high-ranking officers at the school. Dragoje Ivanović saw Drago Nikolic and Lieutenant Yasikovats speaking with a senior VRS officer. PW 143 also saw Nikolic speaking with a senior VR officer who he testified was not from the Zvornik Brigade. Mr. Nikolic's meetings with Lieutenant Yasikovats and senior VRS officers at the school further established that he was there in a supervisory role. The evidence has also shown that Drago Nikolic and his deputy Milorad Terbic were at the Arahovac school after the transport and the execution of the prisoners had started. That evidence is outlined at paragraphs 2703 to 2716 of our brief. PW 101 in particular saw Mr. Nikolic coordinating the transport of the prisoners from the school when he went there sometime after 8:30 p.m. that night. This was around the same time that Milorad Bačarković testified that Drago Nikolic had returned to the Arahovac school just before dark. That's at transcript 11023. I'd also like to briefly touch on the role of the military police at Arahovac, which is summarised at paragraphs 2696 to 2702 of our final brief. Their involvement in the execution process is extremely significant because through Lieutenant Yasikovats, their activities at the school were directed by Drago Nikolić. The military police guarded the prisoners. They helped blindfold the prisoners. They placed the prisoners on trucks that took them to the execution site. PW 142 testified that on at least one occasion, MPs actually escorted the prisoners to the execution site. And we also heard evidence from MP Milorad Bacharković, who was Drago Nikolić's driver, that he escorted a number of these trucks to the water point, which we know was the second execution site. And despite their claims to the contrary, these military police must have known that those prisoners were being executed. They even tried to cover up their involvement at Arahavats by doctoring the MP roster and removing the references to Arahavats on 14 July and the references to Rocevic on 15 July. The trial chamber has also heard credible evidence that Drago Nikolić was at the Arahavats execution site that day. PW 143 saw Drago Nikolić leave the Arahavats school and drive in the direction of the execution site. It's at transcript 6614. PW 101 saw Drago Nikolić at the execution site overseeing the execution process with another senior VRS officer who matched the contemporaneous description of Mr. Popović. I'd like to quickly read what PW 101 said about Drago Nikolić's role at the execution site. He was there because the men who were escorting prisoners from the trucks, he was to direct them. Because the other men who were there were executing people, firing at them, and that was their job. Whereas Drago was with these others. He wasn't yelling at them or anything of that kind. He was simply directing them what to do. At one point during the day on 14 July, Drago Nikolić returned to the Zvornik Brigade headquarters where he met with PW 102 and PW 108. As your honours have heard, Drago Nikolić told PW 102 that he had been executing prisoners at Arahavats. The evidence has shown that the executions continued long after dark. This evidence is outlined at paragraphs 743 to 750 of our brief. Milorad Bacharković testified that he and Drago Nikolić drove past the execution site twice, just after dark. The executions must have been ongoing at that time. Your Honours, there's a single compelling story that emerges from the testimony of these witnesses. Drago Nikolić coordinated the detention, the transport, and the execution of the prisoners at Arahavats, both at the school and at the execution site. And he made sure that those orders to kill the prisoners were carried out. I'd now like to address the defence's submissions about the inferences that can be drawn from Drago Nikolić's meeting with Mr. Popović and Mr. Bayara on the morning of 14 July, and his meeting with Mr. Bayara outside the Petkovsky school on the afternoon of 14 July. At paragraph 1173 of their final brief, the defence have argued that Drago Nikolić merely learned of an imminent exchange of detainees at the meeting with Mr. Popović and Mr. Bayara on the morning of 14 July. And to put this meeting in context, as outlined in our brief and as summarised by Mr. van der Puy this morning, Mr. Bayara and Mr. Popović clearly knew about the murder operation at the time of this meeting, and they were both engaged in it. Drago Nikolić was their trusted colleague and they needed his help. Even if we completely ignore the evidence that Drago Nikolić found out on the night of 13 July that the prisoners were going to be executed. There is no conceivable way that Mr. Popović and Mr. Bayara would have concealed this information from Drago Nikolic.
I hate to interrupt you, but on the live note, the transcript has stopped. Not on the main monitor, but since I suppose shall we move without no, okay. Is there any objection from the defense teams to proceed? Because I suppose they have come on. No objection. We proceed. Thank you.
Thank you, Your Honour. The events that happened after this meeting also show that the murder operation must have been discussed. The prisoners arrived from Brutnuts that morning. The preparations for the executions at Arahavats were completed. The blindfolds were prepared. The trucks were obtained to transport the prisoners. And we know that the excavator was sent to Arahavats before noon that day. PW 104 also testified that Mr. Bayara asked the Zvornik civilian authorities to assist in the burial of the prisoners who were going to be murdered. The 1st Battalion and the 6th Battalion also received information from the Zvornik Brigade Command. The prisoners were going to arrive at the Kula School and the Petkovsky School respectively. These prisoners were killed quickly and efficiently in less than 3 days. In all the surrounding circumstances, the purpose of that meeting on the morning of 14 July could only have been to coordinate the murder operation. The same conclusion applies to Drago Nikolic's meeting with Mr. Bayara outside the Petkovsky School that afternoon. This meeting happened, according to Marko Milosevic, between 4 and 5 p.m. This is after the executions at Arahavats had started and just hours before the prisoners at Petkovsky were killed. It's completely unreasonable to think that Mr. Bayara was hiding information about the murder operation from Drago Nikolic at this time. There can be no doubt that Drago Nikolic knew about the murder operation and was at the very heart of it. Your Honours, the defence has made detailed submissions about Drago Nikolic's role in the detention and execution of prisoners who were held at the Kula School and the Rochevich School. I'm not going to respond to those arguments in detail. They're dealt with at length in our brief, but I would like to just direct Your Honours and the parties to the specific submissions in our brief. Paragraphs 2676 to 2684 outline Nikolic's involvement with the prisoners at Kula and the instructions he gave to Slavko Peric. The evidence has shown at the time he spoke with Slavko Peric, he knew that those prisoners were going to be killed. Paragraphs 2738 to 2762 outlines the evidence that the Zvornik Brigade could send and receive coded telegrams. The 2 coded telegrams were sent to the 2nd Battalion Command in the early morning of 15 July, ordering the formation of an execution squad, and that Drago Nikolic called the 2nd Battalion Command on the morning of 15 July to follow up on those telegrams and insist that executioners needed to be found. Finally, paragraphs 2770 to 2775 outline the evidence from PW 165 that Drago Nikolic went to the Rochevich School on 15 July with Milorad Turbic and issued instructions to the MPs who were there. Again, at the time Drago Nikolic was at the Rochevich School, he knew that the prisoners who were held there were going to be killed. The last point I'd like to address in relation to the joint criminal enterprise to murder the men from Srebrenica is the defence's submissions at paragraphs 1295 to 1301 of their brief that Drago Nikolic had nothing to do with the interrogation and execution of the 4 Brunjevo farm survivors. Now, as outlined at paragraphs 1057 to 1058 of our final trial brief, the evidence has clearly shown that these 3 Muslim men and 1 boy survived the mass executions at Brunjevo farm. These 4 survivors were captured, they were transported to the Zvornik Brigade headquarters, and they were interrogated by military police members Nebojša Jeremic and Čedo Jovic. Nebojša Jeremic testified that Drago Nikolic oversaw the work of the Crime Prevention Unit. That means that the interviews with those 4 survivors had to have taken place with Drago Nikolic's knowledge and his authorization. Drago Nikolic also personally participated in this investigation by attending a lineup at which the 4 survivors identified the 2 Zvornik Brigade soldiers who had assisted them. Nikolic also attended the interview of one of those Zvornik Brigade soldiers, and he signed the ruling against them for collaborating with the enemy. The evidence has shown that after Nikolic found out that these 4 prisoners had survived the Brunjevo farm executions, Nikolic spoke with his commander, Vinko Pandurovic, and the 4 prisoners disappeared shortly thereafter. Drago Nikolic oversaw every aspect of this investigation. There is no question that he was involved in the disappearance and the murder of those 4 victims. I'd like to turn now to the defence's submissions about Mr. Nikolic's involvement in the forcible transfer of the Muslim populations of Srebrenica and Žepa. Mr. Nikolic has argued that he had no knowledge and no involvement in the forcible transfer of the Muslim population from Srebrenica. Your Honours, this argument is both factually and legally incorrect. The indictment makes it clear that the common purpose of that joint criminal enterprise was to force the Muslim populations out of the Srebrenica and Žepa enclaves. The reference to the Muslim population clearly includes the men. Now, as we argued in our Rule 98B submissions, the language to outside the control of the RS, which appears in paragraph 49 of the indictment, does not define the purpose and the goal of that joint criminal enterprise. Now, the evidence shows that most of the Bosnian Muslim population of Srebrenica and Žepa actually were removed to areas outside the RS, but the final destination of those people is not a material element of that crime. It's the act of forcing them out of the enclaves from an area where they were lawfully present, without grounds permissible under international law, that constitutes the criminal element of this offence. The indictment makes it clear that the Muslim men from Srebrenica are alleged to be the victims of forcible transfer. Paragraph 62 of the indictment alleges that the men who were separated from their families in Popović were the victims of forcible transfer. Paragraph 63 of the indictment alleges that the men who surrendered along the road were the victims of forcible transfer. And paragraph 48E specifically states that the forcible transfer of the Muslim population included the forcible busing of the men up to the Zvornik area where they were ultimately executed. The people who receive and detain these victims of forcible transfer at any point are as much a part of the plan to forcibly transfer these individuals as the people who attacked the Srebrenica enclave physically, the people who carried out the separations in Popović, and the people who captured those Muslim men along the road. Mr. Nikolic participated in the coordination of the transport and the detention of those prisoners at a meeting with Mr. Bayara and Mr. Popović on the morning of 14 July. After that meeting, he went and met some of the buses which were transporting those prisoners, and he directed them to our rahavats. He also oversaw the detention of these prisoners once they had actually reached the schools in the Zvornik area. Drago Nikolic was a vital link in the chain which had forced those Muslim men out of the Srebrenica enclave, or out of the enclaves and up to the Zvornik area. He clearly knew about and was involved in the forcible transfer, joint criminal enterprise. I'd like to turn now briefly to two legal points which are raised in the defence's brief. Firstly, the defence have argued that the existence of a state policy to commit genocide is a necessary element of the crime. Quite simply, it's not. It's not contained in the Genocide Convention, it's not contained in the statute of our tribunal, and the appeals chamber in the Jelačić appeals judgment specifically states at paragraph 48 that the existence of a plan or policy is not a legal ingredient of the crime. In relation to conspiracy to commit genocide, the defence has argued at paragraphs 141 to 187 of their final brief and paragraphs 1596 to 1659 that even if there was a conspiracy to commit genocide, it was concluded sometime on the night of 11 July and Drago Nikolic could not subsequently join it. The conspiracy is clearly outlined at paragraph 34 of the indictment. It has the same duration and the same underlying facts as the joint criminal enterprise to murder the men from Srebrenica. Now, the law is clear that a person is liable for conspiracy to commit genocide at the moment they enter an agreement with others to commit genocide. But that doesn't mean that the actual conspiracy stops at that point. As different people agreed to join that conspiracy on 12 July, on 13 July, on 14 July, on 15 July, that is the moment at which they are guilty of the crime to commit genocide. It's that act of agreement which their criminal liability attaches to. Your Honours, the moment when Drago Nikolic agreed to join the conspiracy is clear. On the night of 13 July, he received a call and was asked to join in the murder operation. Shortly afterwards, he called his commander and asked to be relieved from the IKM, and he was relieved from the IKM. The call to his commander and his relief from the IKM are conclusive proof that Drago Nikolic had agreed with others to commit genocide. The last point I'd like to address briefly are the defence's submissions on mitigation. Paragraphs 1334 and 1336, for example, of the defence's brief. They argue that Drago Nikolic's junior rank, the fact that he was following orders, and the fact that he was engulfed by these events diminishes his responsibility and is important for sentencing purposes. These arguments should be given no weight whatsoever. Drago Nikolic was not obliged to commit these crimes. Drago Nikolic wasn't forced to follow any orders. He was not engulfed by events beyond his control. He had a choice. There's no doubt that it would have taken a lot of moral courage, but he could have chosen to say no, and it was his legal and his moral obligation to say no. Instead, He requested and he received authorization to leave his post at the IKM and join in that genocidal plan. And every criminal act he participated in during the following days and weeks was by his choice. These are not the actions of a junior officer who was out of his depth or who was pressured into following orders. These are the actions of a man who knowingly and who intentionally committed the crimes with which he is charged in the indictment. And on that basis, we ask Your Honours to find him guilty of all the counts with which he is charged. Thank you.
Thank you, Mr. Mitchell. Who's next, Mr. Elderkin?
Good morning, Your Honour. Yes, I am going to just move up to the podium and go next. Your Honours, Counsel, good morning. Firstly, I'm going to address certain issues in relation to the opportunistic killings and persecutions charged in the indictment as foreseeable consequences of the two joint criminal enterprises. The indictment sets out the relevant crime incidents at paragraphs 31 and 48, while paragraphs 37 and 83 charge that such crimes were foreseeable to the members of the murder JCE and the forcible removal JCE. I'm not going to rehearse the factual details which are covered in the final brief, starting at page 119 for Popović, Bratanats, and the Kravica supermarket, and starting at page 224 for the Petkovci school. However, I will deal with specific factual allegations where those have been raised in the defence briefs. As a preliminary matter, the prosecution yesterday filed a corrigendum to the final brief, which stated that certain opportunistic killings were no longer charged. As stated in this corrigendum, as well as in the prosecution's submission of the 15th of February 2008, the opportunistic killing incidents listed at paragraphs 31.1b and C of the indictment are not proven. Therefore, the only opportunistic killings charged at Popović are the 9 bodies found near the UN compound on the Budak side of the main road, which is paragraph 31.1a, and the summary execution of 1 man near the White House, which is paragraph 31.1d. Although the indictment refers to the 9 men being killed on the 12th of July, the evidence in the case has shown that 9 men were killed on the 13th of July at that location. Also, the opportunistic killing incident near the Kravica supermarket, listed at paragraph 31.3 of the indictment, include the allegation that, I quote, a VRS or MUP soldier placed his rifle barrel into the mouth of a Bosnian Muslim prisoner and summarily executed the man. As stated in the corrigendum, there is insufficient evidence to prove that this man was killed. However, as detailed in the prosecution's final brief, the other violence and killings near the Kravica supermarket have been proven. A number of defence briefs assert that individual accused did not know about the opportunistic killing incidents that actually occurred and did not contribute to those incidents. I'm referring, for example, to the Beara final brief at paragraphs 487 to 490, the Militic final brief at paragraphs 497 and 498, the Nikolic final brief at paragraphs 1309 to 1312, and the Pandurovic final brief at page 228. However, these elements are not relevant to a JCE3 analysis. What the prosecution has to prove is that the crimes occurred, that such crimes were the natural and foreseeable consequences of carrying out the JCEs, and that the accused JCE members willingly took that risk. Based on this framework, many of the points raised in the defence briefs supposedly concerning liability for opportunistic killings in fact concern matters entirely outside the scope of the relevant analysis. I want to make two brief points as to the applicable law. The first is the degree of foreseeability.
Mr. Elderkin, where was it? Before you do so, when referring to opportunistic killings, 31, yeah. You dealt with the ones in Potocari, or related to Potocari, and the ones related to Kravica supermarket, or Kravica. You haven't said anything about the ones alleged to have taken place in Bratonets and the Petkovsky. Do you have a position on those?
It's the prosecution's position that they are proven, okay, and the charges are left untouched.
All right, okay.
I certainly didn't mention them, Your Honour, because we weren't making any alterations.
Okay, thank you.
So as to the applicable law, Your Honours, then the first point is the degree of foreseeability. The Appeals Chamber has affirmed in a 25th of June 2009 decision in the Karadzic case that, I quote, plotted on a spectrum of likelihood, the JCE3 mens rea standard does not require an understanding that a deviatory crime would probably be committed. It does, however, require that the possibility a crime could be committed is sufficiently substantial as to be foreseeable to an accused. Second is the fact that the Appeals Chamber has held that an accused JCE member can be guilty of specific intent crimes which are foreseeable consequences of the JCE. And that's an Appeals Chamber decision from Berginen on interlocutory appeal dated the 19th of March 2004. And this jurisprudence is on point, and it applies to the crimes charged in this case. As regards foreseeability, the Guerrero final brief argues at paragraph 48 that, I quote, "It is the defence position that as these crimes were, in fact, carried out for reasons of personal revenge, it would have been completely impossible for Milan Guerrero to foresee their commission, as they bore no relationship whatsoever to the forcible transfer operation. Your Honours, the evidence supports entirely the opposite conclusion. The circumstances in which the forcible removal JCE and the murder JCE took place were such that spontaneous killings or revenge killings were objectively foreseeable as possible consequences of those operations. I won't go into great detail in describing this, but as explained throughout the case, retaliatory violence had occurred in and around the Srebrenica enclave from 1992 onwards. Furthermore, violence towards the Srebrenica Muslims was clearly foreseeable as part of the policy to ethnically cleanse areas claimed as Bosnian Serb land, including the Drina River Valley, and particularly was foreseeable in light of the brutal history of the war. As well as having to be objectively foreseeable, there's also a subjective requirement that the crimes were foreseeable to each accused. However, as all of the accused were officers of the armed forces of Republika Srpska throughout the war, there can be no suggestion that any one of them lacked the necessary knowledge of the historical build-up, hatred, and policy of ethnic cleansing that existed prior to July 1995, such that they could not foresee that serious violence, including murder, might result from the criminal plan to rid the enclaves of their Muslim population. As regards what distinguishes opportunistic killings from the organised mass killings of July 1995, the indictment makes this clear at paragraph 83, part of which reads as follows. The term opportunistic is used in this indictment to describe killings and other criminal acts carried out by individual soldiers acting on their own, likely without orders from superior officers. So, these killings were not part of the planned sequence of events of the murder JCE. They took place at locations other than the chosen execution sites and for reasons other than military orders. They represent the level of attendant violence that was accepted by the JCE members as the possible consequence of the plan to rid Srebrenica of its Muslim population. Each of the charged incidents fits this characterization. The killings in Potocari, Bratanac, near the Kravica supermarket, and at the Petkovci school occurred at locations where they risked discovery by Dutch bat or by uninvolved members of the local population. Furthermore, they did not involve the killing of all the Muslim men who were at those locations, indicating that they were carried out either as spontaneous acts of violence or as acts of targeted revenge. Even after the murder operation started, these killings occurred in a way that was clearly opportunistic and foreseeable in a way that the vast and organized mass killings were not foreseeable as a consequence of the forcible removal, JCE. That is the distinction. That is why the forcible removal JCE members are liable for these killings, but not the mass executions. Next, I would like to address certain factual allegations, specifically concerning the 9 men killed near Potočari. The Guerrero final brief makes a number of arguments about these victims, with the following proposed as reasonable possibilities. First, this is at paragraphs 75 and 76 of the Guerrero brief, it is argued that the 9 bodies were found in the Yaglici and Shushnari area, where the Muslim men formed the column and set off towards Tuzla on the evening of the 11th of July, suggesting that the victims could have been combatant members of the column, and, I quote, and that they may have perished as a result of earlier mutual conflicts or acts of personal revenge committed by individuals within the column. Second, it is argued that the 9 men may have been killed by retreating Bosnian Muslim fighters who were seen on the 11th of July, but who had left for the woods by 12th of July. And that's at paragraph 77 of the Guerrero brief. Third, it's argued that the 9 men may have been killed by an individual seen by Major Rutan fleeing the scene, and that's at paragraph 74 of the Guerrero brief. And fourth, the fact that identification documents were found near the bodies is argued to be inconsistent with the VRS forces' practice of confiscating prisoners' IDs immediately, suggesting that the 9 men may not have been killed by VRS forces. And that's paragraph 78 of the Guerrero brief. These supposed reasonable doubts are first of all based on inaccurate foundations. It may just be a simple error, but the bodies were found only a few hundred meters from the main road in Potočari, not in the Yaglici and Shushnari area. Those villages are more than 5 kilometers away from Potočari over the hills. I don't need to show this in court, but it can be seen, for example, on the Krivaya 95 map, which is P01463. So it's not correct to say that they were found in the area where the Muslim men gathered before leaving in the column. Second, it's clear that the 9 men were killed only shortly before Major Rutan and Lieutenant Costa saw them on the 13th of July. And Rutan's Kirstich testimony, and this is page 2140, he said the following when he saw the bodies. He said the following of when he saw the bodies. I quote, "The blood was still running. There were no flies on them. It was very warm that day, so you could easily say that it hadn't been long ago that they were shot." When you compare this with other evidence about how quickly bodies deteriorated in the heat, it's clear that those 9 men were killed on the morning of the 13th of July. For comparison, Muslim column member PW116, in his witness statement, which is exhibit P02206, described how he came across bodies in the hills above Kravica and Sandici on the 13th of July, which cannot have been there for more than a day, since the column only set off on the night of the 11th of July from Yaglici and Shushnari, and would have passed through that area on the 12th of July. He said, I quote, "It was very hot and flies came to the bodies. The smell was terrible. I could not look at the bodies anymore." In that kind of heat, Rutan cannot have seen the bodies very long after they were killed. In response to the other suggested scenarios put forward in the Guerrero brief, the first point is that it is not a reasonable possibility that Muslim men in civilian clothes who were alive within a few hundred meters of the main Potocari road on the morning of the 13th of July were members of the Muslim column, or had been killed by the men in the column or by retreating Muslim fighters fleeing to join the column. That group had gathered far away and was long gone by that time. The next supposedly reasonable scenario, that a Muslim man in civilian clothes seen fleeing from the general area might have killed the 9 men, is again simply not credible. It is not reasonable that a killer would stay around at the murder scene long enough to be seen fleeing from the general area when the Dutch BAT officers, responding to rumours, arrived to investigate. Anyway, the only Muslim men in Potocari on the 13th of July were those in the crowd of refugees, and they had no motivation and were not in a position to carry out mass murders of other Muslim men. Lastly, it's not reasonable to draw any conclusion based on the presence of the victims' identification documents near the bodies that the murderers may not have been members of the Bosnian Serb forces. Clearly, not all Muslim men had their IDs taken away when they were captured or separated by VRS or MUP soldiers, and there are plenty of cases of IDs being found in the mass graves. Guerrero's arguments that the 9 men may have been killed by fellow Muslims are predicated on their having been killed when there were still Muslim fighters in the Potocari area. The only evidence that could possibly suggest this is that of witness PW 114, who saw 9 or 10 bodies on what he said was the 12th of July, but he also insisted that it was the second day of the transport of the Muslim population out of Potocari, which of course was the 13th of July. Furthermore, PW 114 testified that he didn't know when the men had been killed, but on cross-examination answered the question, I quote, "Can you tell us if you know when these people were killed?" Answer, "No, I don't know the time. I was there at noon, so it must be maybe on the 11th or on the 12th in the morning." And that's a transcript reference 3164. Either PW 114 saw different bodies from those seen by Rutten and Costa, or he saw the bodies on the 13th of July. The obvious conclusion is that all 3 witnesses saw the same bodies on the same day. This is clear both from their similar testimonies and from the fact that only 9 bodies have been exhumed from the field just by the stream where the bodies were seen. And if you look at exhibit P03897, this shows clearly how all 3 eyewitnesses recalled seeing bodies within a few meters of where 9 bodies were subsequently exhumed. In these circumstances, PW 114's failure to resolve the inconsistency of seeing the bodies on the 12th of July, but at the same time on the second day of the transportations, doesn't matter. It is clear that the bodies of 9 men were found on the 13th, and those men were killed on the 13th. However, even if they had been killed on the 12th of July, there is no way that these men could have been killed by mysterious Muslims carrying out internal revenge killings within only a few hundred meters of the huge BRS and MOOP presence in Potocari on the 12th and 13th of July, as seen, for example, on the trial video, which is exhibit P02047. Next, I want to address an argument raised in the Pindurović final brief, which at page 210 argues that, I quote, "The indictment alleges also that the crime of persecution was a necessary and foreseeable consequence of the plan to transfer the population. The defence frankly wonder whether this was a mistake in the indictment's drafting. The particulars of paragraph 48 of the indictment cannot properly be characterised as individual criminal acts when it actually describes the whole alleged murder and forcible transfer operations. Paragraph 83 of the indictment states that it was foreseeable to the accused, I quote, that individual criminal acts such as individual opportunistic killings and persecutory acts, as described in paragraphs 31 and 48 of this indictment, would be carried out by Serb forces during the joint criminal enterprise to forcibly transfer and deport the populations of the Srebrenica and Žepa enclaves. Clearly, in addition to the opportunistic killings, points 48b, c, and d are the relevant persecutory acts for consideration as foreseeable crimes pursuant to JCE 3. 48b being the cruel and inhumane treatment of Bosnian Muslim civilians, including murder and severe beatings at Potocari and in detention facilities in Bratunac and Zvornik. 48c being the terrorizing of Bosnian Muslim civilians in Srebrenica and at Potocari. And 48d being the destruction of personal property and effects belonging to the Bosnian Muslims. These crimes of persecution were the natural and foreseeable consequences of the forcible removal JCE, irrespective of their nature as crimes against humanity. The chapeau requirements for such crimes are fulfilled by the nature of the attack on Srebrenica as a widespread and systematic attack against a civilian population, and because the persecutory acts themselves had a sufficient nexus with that attack, since they were carried out by members of the same attacking forces and were directed against members of the same population. Once those elements are proven, the remaining question is whether the actual persecutory acts were foreseeable. For the reasons that I already explained, namely the violent history of the war and hatred against the Muslims, and specifically against the Srebrenica Muslims, they were indeed foreseeable. Finally, I want to reiterate what Mr. Mitchell has already said, that the Muslim men who were taken to the Zvornik area did not lose their status as victims of the forcible transfer operation just because at some point they also became the intended victims of the murder operation. The men who were separated in Potocari or captured from the fleeing column were transported away from the Srebrenica enclave. The possibility of opportunistic crimes being committed against these men when they were moved through Bratunac and through locations in the Zvornik area was foreseeable to the members of the forcible removal JCE, just as were the crimes committed against Muslims in the crowd at Potocari, such as the man shot near the White House or the 9 men killed near the stream towards Budak. Your Honours, I have a very brief further submission concerning reburials, and this is simply to address questions raised in the Nikolic final brief concerning the inclusion of the reburials in the indictment. Again, I'm not going to deal with the factual details or the nature of the accused's participation in the operation. Those are covered in the prosecution's final brief, starting at page 311, as well as in the sections concerning the individual accused. I will just deal with the arguments raised in the section of the Nikolic brief entitled "The alleged reburial operation has no purpose," which is at paragraphs 260 to 274. The conclusion of this section, at paragraph 274, states, "For all intents and purposes, the inclusion of the alleged reburial operation into the indictment serves no apparent goal. The defence submits that the trial chamber must disregard it as either A, a component of the alleged genocide, B, reasonably foreseeable consequence of the alleged murder operation, C, a crime in and of itself, and D, ex post facto aiding and abetting the alleged murder operation." The conclusion that a reburial operation is irrelevant is wrong, and I want to highlight the reasons why the reburial operation is included in the indictment, since it was a major planned military undertaking, and it should inform the trial chamber's deliberations concerning the murder JCE. The indictment at paragraph 32 indeed states that, I quote, "The reburial operation was a natural and foreseeable consequence of the execution and original burial plan conceived by the joint criminal enterprise." This characterization reflects the prosecution's evidence that the reburials were foreseeable to the members of the murder JCE in July 1995. It was foreseeable from the outset of the murder JCE that the initial steps taken to conceal the crimes in July 1995 might not be sufficient because the killings and burials were so extensive and so hastily organized. That such crimes could not be concealed so easily was borne out by what actually occurred. The disappearance of thousands of Muslim men from Srebrenica quickly became well known, and the burials of many of the victims were carried out hurriedly and involved civilian as well as military personnel. The trial chamber should, for example, consider the testimony of witnesses PW 161, PW 170, and PW 104. Because the killings and burials were not well concealed, it was foreseeable that further steps might be needed to hide the crimes. In any event, this foreseeability is not a necessary element to establish the guilt of the accused under any of the modes of liability charged, since all 5 accused charged with genocide both joined and contributed to the JCE in July 1995, before the reburial operation started. Those who were involved in the reburial operation, in other words, all 5 other than Borovjanin, further contributed to the crimes by their involvement in the reburials at a later stage. As well as taking into account the reburial operation when considering the liability of the individual accused, the operation is also hugely significant as an act of concealment, which confirms the knowledge and intent of the JCE members as participants of a massive criminal enterprise to murder the Muslim men of Srebrenica. Finally, as the trial chamber will hear from Ms. Sholian, the destruction of the Muslim women and children was a component of the genocide, and the reburials clearly were an element which contributed to the inability of the surviving Muslim population to recover from the loss of their men, since afterwards it would be even more difficult to locate, identify, mourn, and come to terms with the fate of their murdered fathers, brothers, husbands, and sons. Those are my submissions, Your Honours.
Thank you. Okay, Ms. Solian? No. Ms.
Your Honours, Counsel, good afternoon. The prosecution has proven beyond a reasonable doubt that the 5 accused, Vinko Pandurević, Ljubomir Borovčanin, Ljubiša Bera, Vujadin Popović, and Drago Nikolić, are responsible for genocide committed against the Bosnian Muslim population of eastern Bosnia, as charged in paragraphs 26 to 33 of the indictment. It is proven that, with the goal of destroying the Bosnian Muslim population of eastern Bosnia, the VRS and RS MUP forces carried out the following genocidal acts, enumerated in Article 4.2, Sections A through D of the statute. A. They killed over 7,000 Bosnian Muslim men from Srebrenica. B. They caused serious bodily or mental harm to both the male and female members of the Bosnian Muslim population of Srebrenica and Žepa. C. They created conditions contributing to the physical destruction of the Bosnian Muslim population of Srebrenica and Žepa. And D. They contributed to the failure of the Muslim population of Srebrenica and Žepa to live and reproduce normally. I shall briefly address 2 issues related to the genocide count. First, I will address some of the factual issues raised by the defense concerning the number of Srebrenica victims, more specifically the number of persons killed, as charged in paragraphs 26A and paragraphs 27 to 32 of the indictment. After that, I shall briefly speak about the destruction of the Muslim population of eastern Bosnia, focusing in particular on the destruction of women and children, caused by the separations of the men at Potočari, their subsequent murder, as well as by the forcible transfers from the Srebrenica and Žepa enclaves, as charged in paragraph 26B and paragraph 33 of the indictment. With respect to the first issue, Your Honours, the number of Srebrenica victims, the defense argues that anywhere from 1,500 to 3,000 Srebrenica persons died in legitimate combat, as well as a result of landmines, suicides, or friendly fires. You can find references to this in Popović final brief paragraph 708 and 886, the Bera final brief paragraphs 584 and 586, and the Nikolic final brief at paragraph 1493. Defense also argues that the figure 3,000 is indicative of the total number of missing persons from Srebrenica, and that, and I quote, not in excess of 2,000 to 3,000 victims were killed in Srebrenica. This is from the Nikolic final brief at paragraph 1494. Evidence, however, shows that the defense figures wildly underestimate the number of Srebrenica victims. First of all, evidence shows that almost 8,000 persons from Srebrenica are missing. Based on a rigorous demographic analysis, the minimal number of Srebrenica missing persons was determined to be 7,661. As you will recall from Mr. Brumburg's 2000 report on the number of missing and dead from Srebrenica, and this is Exhibit P571, this is a conservative number. In some cases, entire families went missing, leaving no surviving family member to register the information with the ICRC. This minimum demographic figure was revised to 7,826 Srebrenica missing persons in January 2008, when the list was cross-referenced with the then-current ICMP DNA matching data. This would have been Exhibit P3002, the October 2007 ICMP update, and is also reflected in Exhibit P3159, which was the then report on the ICMP's DNA identifications. Based on ICMP's recent 10 April 2009 Srebrenica tracking chart, Exhibit P4500, the number of persons reported to ICMP as missing from Srebrenica and is represented by donor relative blood samples is 7,789, a figure very close to demographic accounting, but obtained independently of the ICRC. I note that the Nikolic defense at paragraph 1469 of its brief incorrectly states that, I quote, the 2009 ICMP update is based on information provided by the family of the missing person to the ICRC, end of quote. Dr. Parsons, in fact, testified that information regarding individuals reported missing regarding any event in Bosnia came directly to the ICMP from the family members. So, to quote, to associate it with Srebrenica, that would have been information that the family provided to us, end of quote, reference page 20873 of the transcript. Dr. Parsons also explained that ICMP's expert interview teams meet with families, obtain genetic blood samples, properly record all relevant information, including the date and place of disappearance of the missing persons, which are then nominally set as 11 July 1995 and as either Potocari or Forest, which are then placed on the match report and update for purposes of keeping track of the ICMP Srebrenica cases in an internally consistent manner. The reference to this is at 20875 to 20876. In short, the ICMP information is based on information and blood samples provided by family members to the ICMP, not the ICRC. Now, of the almost 8,000 Srebrenica persons reported missing, we have evidence that approximately 2,000 of those persons were separated at Potocari. We also have evidence that at least 5,000 of them were captured or surrendered from the column along the Bratunac-Konjević Polje road. And finally, that at least 648 of these individuals identified from surface remains were killed along the column route, though not only in combat. Let's take a closer look at these figures. With respect to the evidence that shows approximately 2,000 men separated at Potocari, first of all, we have the demographic evidence, which shows that 2,070 individuals were reported missing from Potocari in the month of July 1995. We see this at Exhibit P2413, which is the report from 2003. In our final brief at paragraph 496, the dates of disappearance for men reported missing from Potocari were narrowed to just 10 to 13 July, and the number was still 2,003. Currently, 1,443 individuals reported to the ICRC as missing from Potocari have been identified through DNA. This can be verified by comparing the most recent ICMP update, exhibit number P4494, with the previously listed exhibit P3159A, which is the 2007 progress report on ICMP's identifications, which also contains the data on ICRC dates and place of disappearance.
For the purpose of the record, since the number of individuals did not show up in the transcript in line 24.
Apologies, Your Honor.
Yeah, no, it's not your fault.
The
What
number
was the number of individuals reported?
currently identified is 1,443.
Okay, thank you.
The vast majority of these individuals, Your Honors, can be found in the primary.
For 1 moment, for the record, it's the transcript says now 1,943. I heard you say 1,443.
443.
Okay, thank you.
Slow down, please.
That would be 1,443.
Thank you.
Now you're 1443. The vast majority of these individuals can be found in the primary and secondary graves related to all the major executions and execution sites, including Kravica, Orahovac, Petkovci Dam, Kozluk, and Branjevo Farm, as well as Pilica. Can also be found in the primary undisturbed graves, such as Bishina, Nova Kasaba, Konjević Polje, and others. In addition, some of these individuals, reported as having gone missing from Potocari, have been identified from surface remains. As an example, 12 of the 14 individuals identified via DNA from the Kozluk surface remains, which we can find in Confidential Annex D to the Dushanyan's report. This is exhibit number P4491. They were found, and the most reasonable inference is that they were separated at Potocari. This specifically contradicts the defense arguments by the Beara defense at paragraph 635, as well as the Popović defense argument at paragraph 755, that the Kozluk surface remains are legitimate combat casualties of a battle taking place in the area. Second, of almost 8,000 persons reported missing, at least 5,000 were captured along the Bratunac-Konjević Polje road. While the evidence concerning the movement of the column, the surrenders, the captures, is dealt with greater detail in the prosecution final brief at paragraphs 518 through 544, I'd like to make just a few basic points in order to respond to defense arguments. Evidence has shown that approximately 15,000 Muslim civilians and ABIH 28th Division soldiers gathered near the village of Jaglici in Šušnjari on the eve of 11 July and set out westward in a column towards the Muslim-held territory. Now, I'm emphasizing the word westward in order to address an entirely unsupported argument at paragraph 613 of the Beara defense final brief, namely that the column route, and I quote, would have very likely taken soldiers through the area of Ravnice, where the column may have been attacked or ambushed, end of quote. Now, this argument is a part of Beara's broader argument that bodies found in the Glogova, Ravnice, and Zeleni Jadar graves got there as a result of legitimate combat. there is no evidence whatsoever in the record that the column ever went in such a convoluted northeastern direction in order to reach the Konjević-Polje intersection, which is squarely to the west on their way northeast to Tuzla. We only need to take a look at the map showing the movement of the column, which is exhibit number P2110, in order to see that the column went from Šušnjari and Jagliči through the so-called Pobuđe area, south of Bratunac, well south of Glogova and Ravnica graves, and moving westward in the hills south of the Bratunac and Konjević-Polje road towards the Konjević-Polje intersection. For further reference, you can also see exhibit P04524, which was the map of primary connections from primary to secondary graves based on DNA and forensic evidence. Evidence shows that as many as 6,000 men and boys from the column were captured or surrendered along the road. An intercepted conversation at 17:30 hours on July 13th, which is exhibit P1143A, shows that the Bosnian Serbs had captured approximately 6,000 Muslim men along the Bratunac-Konjević-Polje road that day. It tells us that approximately 1,500 to 2,000 men were detained at three major sites: Nova Kasaba, Konjević-Polje, Sandići Meadow. And we know that the survivors such as PW-116, PW-113, PW-111, who were captured and placed at Nova Kasaba or Sandići Meadow, corroborate those numbers. Demographic evidence shows that at least 4,600 individuals were reported as missing from the area along the route of the column between Jagliči and Šušnjari and Konjević-Polje. Roughly, this number includes 1,085 men reported as missing from the forest, 2,338 men reported as missing from Konjević-Polje, Kravica, or Kamenica, and approximately 1,200 persons reported as missing from smaller locations in the Pobuđe area along the route of the column prior to the Konjević-Polje crossing. We can see this at exhibits P2413, the demographic report, specifically at ERN 0501-6201, as well as exhibit P3159A, the 2007 progress report. Now, what do we know about the Muslim men who were captured or surrendered from the forest in various locations? We will see that the vast majority of these individuals have been identified in the primary and secondary mass graves related to all the major executions and execution sites, including Kravica, Orahovac, Petkovci Dam, Kozluk, Branjevo Farm and Pilica, as well as in primary undisturbed graves such as Trnovo, Pišina, Nova Kasaba, Konjević-Polje. Now, we know that in addition to the approximately 2,000 men who were separated in Potočari, as well as at least 5,000 men who were surrendered or captured along the Bratunac-Konjević-Polje road, there are 648 individuals whose remains have been identified at the surface, primarily along the route of the column. Before discussing these individuals, let's just briefly look at the DNA evidence concerning the numbers of individuals in mass graves. If I may, Your Honors, could I take the break now, and we'll continue immediately thereafter.
Thank you. I think that's perfect. We'll resume in 25 minutes' time. Thank you.
All rise for your full